Well, tonight on this special interactive news segment for our Sunday edition, with me on the set, she's none other than Maria Kamara, the representative of the ICC chapter in East African region. Kamara, thanks for joining me on this special interactive news segment where we discuss issues that affect the people. And tonight, the issue is about the LRA former commander who will be appearing before the ICC court tomorrow, Dominic Ongwen. Well, from the ICC perspective, a lot of issues are being said about this LRA notorious commander, Dominic Ongwen. And the issue is about Uganda offering legal representation to him. It is the country that actually proposed his name and other colleagues of his who are 5 in number for indictment in the ICC. But here it is offering legal representation to him. How do you perceive this as ICC?
At the ICC, the cases are against individuals. It's individual criminal responsibility. It's not the state, the ICC versus the state. So the question of state representation does not come to play here. Individual, independent lawyers that meet the criteria may represent an accused or a suspect at the ICC, but not in the capacity as a state representing them. A state representative may only be required to be present in the courtroom if the matters being discussed directly impact the state or have to do with the state. For example, issues of admissibility, of jurisdiction, of cooperation, or the release of the suspect. For such sensitive issues that may require the attention of the state, they may have a representative. Aside from that, it is purely an individual or the court, the prosecutor versus the individual, so state representation.
Is this going to be the first incident where a country proposes an indictment of certain individuals and becomes the same country to offer legal representation for that country, for such a person?
I am not going to be very certain about what you're suggesting because as of now there is an initial appearance taking place tomorrow, and only one person has been temporarily assigned, a duty counsel, Madame Helen Sese, to represent Dominic Ongwen for the purposes of the initial appearance. No other counsel has been appointed. So I am wondering where this is coming from, but no other counsel would be representing Dominic Ongwen in tomorrow's hearings. And for subsequent sessions, once the initial appearance wraps up, the duty counsel will hand over the file to any other lawyer or a team of lawyers, lead counsel, co-lead counsel, that will be appointed by Dominic Ongwen.
Definitely. That means the statement that had earlier been made here in Uganda by the State Minister for International Relations, Okello Oryem, that Uganda is going to provide legal representation for Dominic Ongwen, and that means that's baseless, given the fact that you have no idea about it.
Only lawyers, individual lawyers, independent lawyers, in their capacities as lawyers, will represent Dominic Ongwen. A state coming in the context of a state who does not have that possibility to represent an accused person or a suspect. As I already hinted, representation or participation by a state would only come if the judges so invite them, and only if the matters being discussed had to do with the state. And I highlighted them, issues of cooperation, if they are discussing admissibility or jurisdiction or the release of a suspect or an accused person. Other than that, it's not what you're proposing.
The issue to do with him being perceived to be a victim of abduction, having been abducted in 1990 at the age of 10 years to join the LRA. And some lawyers are arguing that it's quite a very unique precedent and in the ICC court. How do you look at this?
The trial chamber, pre-trial chamber 2 issued an arrest warrant based on information that is presented by the Office of the Prosecutor, alleging that Dominic Ongwen is a commander of a brigade under the LRA, and under his command, he was alleged to have committed 3 counts of crimes against humanity and 4 counts of war crimes of different categories of murder, enslavement, displacement of the population, torture, other inhuman acts, or inflicting bodily harm on civilian population. These are the categories forming 3 charges of crimes against humanity and 4 of war crimes under his command. These are the allegations, and you have explained what is the perception of his circumstance. What the judges will do is to evaluate the facts presented to them, to evaluate the circumstance of the individual based on the evidence that is presented, and if possible, to make an assessment of what leadership role and at which point those crimes may have been committed. So it's only when a full-scale judicial process starts, it's when those legal arguments will come up. There's a lot that is out there to be discussed. The judges have said, come to the court, now we have you. These are the allegations.
Earlier in the beginning of this interactive news segment, you did say that what's going exactly to happen tomorrow will be the judge trying to find out exactly whether this is the Dominic Ongwen. How do they do it?
The arrest warrant has specific details of the person who is wanted. The name, where he was born, the date of birth, and another identifiers. So the judges will put to them, what's your name, where were you born, and few other, what is your position, and so on and so forth. So if these information correlates with what is on the arrest warrant, that is already the initial appearance of confirmation of the identity of the suspect. And moving forward from there, the charges will be read. And the judges have to understand that have to ensure that he understands the charges fully, at the same time read out his right to him under the Rome Statute of the ICC.
So basically, as we speak now, the court has already secured an actually person who will help it in translating?
I'm not predicting that he's going to speak in Acholi. I'm just looking at the practices of the court, that any language a suspect prefers to communicate in the courtroom, he informs the court in good time, and the court ensures that those professional people are on standby so that when they are needed, they are readily available to provide those services.
The surrendering of Dominic Ongwen, accepting to be arraigned before the court, as the ICC, how do you look at it in terms of, is it a success story to the court, in other words, toward the end of the LRA war?
I'm not coming to the LRA war. First of all, let me refer to the statement of the prosecutor, Madame Fatou Bensouda, after the confirmation that Dominic Ongwen was indeed in the custody of the court. She did make the statement that it's the beginning of the closure of the chapter of the LRA by having one of its top commander in the custody of the court, and she sent the message to other commanders wanted by the court to stop committing atrocities and surrender themselves to the ICC. It is the hope that suspects will surrender themselves. And in that statement, she also clearly pointed out something that is very key. No matter how long it might take, justice will be served. It may be delayed. It would be unfortunate if the suspect dies. Those are the extreme circumstances you will look at. But if the suspect is alive, no matter how long it might take, time will catch up with the suspect, and justice will be served.
As a representative of the ICC chapter in the region here, the East African region, what should be the expectations of people who suffered at the hands of these LRA notorious commanders?
At the ICC, victims have the right to participate in the courtroom, to express their views and concerns, their interest in a particular case. Of course, this interest should not be prejudiced to the rights of the accused persons or the suspect. So this will present victims the unique opportunity to present their voices to the judges, their concerns, their interests on several matters during different stages of the judicial proceedings.
How do you treat these statements being made by a club of African leaders describing the ICC as an imperialistic court targeting African leaders on the African continent?
The court has always said it is an independent court. Various officials of the court, and this is the key principle that the court operates on. It's independent, it's neutral. No individual, no state determines or controls what the judges decide. The judges are guided strictly by the legal basis of the court, the procedures, and not a single individual. The court goes for people, persons who are most responsible for the crimes that fall under the jurisdiction of the ICC. The court only investigates these individuals if it is satisfied that they may have committed these crimes as a last resort. So the principle of complementarity comes in here. The court will only investigate and prosecute if a state is unable and unwilling. On the key thrust of the accusations, African states have been a key partner of the ICC. Right from the establishment of the ICC, the drafting of the Rome Statute, over 45 African states were present in Rome to discuss what will later become the ICC. Today, over 30 member states are from Africa. In fact, Africa forms the single largest majority bloc of the membership of the ICC because there are common values that African states share with the ICC. The common values of respect for human rights, respect for individuals, respect for accountability. So the ICC does not target Africans. It does not target states. It protects victims.
What do we expect tomorrow at Hotel Africana?
The plan tomorrow is to bring together journalists at Hotel Africana to view the confirmation of charges hearing. It's not going to be a long process. It's a very short one. The initial appearance, sorry, it's not the confirmation, I beg your pardon. To view the initial appearance of Dominic Ongwen, and after which we intend to have an interactive session in the process.
Seeing for the first time somebody speaking actually in the International Criminal Court. Thank you for joining me on this interactive news segment, Maria, where we discuss issues that